All right, boys and girls, Todd Vanderbilt back here again for another edition of Freedom Steel. Friday, February 24th, and this morning at 10 o'clock, Judge McGlynn held a status conference for the attorneys in the case. And so we got some news here. So, a couple of things. There was a stipulation order that was drafted to kind of do some case management stuff and make it a little easier. Part of it is that the Attorney General gets to sit there and file a single brief for all four cases that are here. The AG's office is, instead of filing four separate briefs and four separate cases, they're going to roll it all into one. With that, the district court rule generally disfavors reply briefs in cases like that, but we will get a chance to do a reply brief. Each of the four plaintiffs groups will get to do a reply brief of 15 pages back to the court. The judge was he's cognizant that he doesn't want to be papered to death, were his words. And he doesn't want redundant and duplicative filings. So I think his feeling is he doesn't want 3 or 4 briefs from the plaintiffs that all essentially argue the same thing. So it'll be interesting what kind of coordination we can get out of all four groups. So with that, the judge also made a determination it's a consolidation, but it's also a coordination effort. So the lead case is now Barnett. The ISRA SAF case, despite being low numbered, is not the lead case for the ongoing litigation. That puts Paul Clement and Aaron Murphy as the lead attorneys for what's going to be happening. I think the judge saw Mr. Clement's name on there, and it is pure speculation on my part, but had an idea of the quality of representation that he would be seeing and the professionalism out of Mr. Clement being a former Solicitor General. So good news is our attorneys have worked with them on other cases in the past, so we have a relationship with that law firm. You've got the 5th and 14th Amendment issues that were raised in the Langley case by Tom Magg have been put off until all the 2A issues are resolved. So the state has an obligation to have their brief, and they will not be given an extension, to have their brief in opposition to the motion for a preliminary injunction filed next Thursday. They have just a week to get their work wrapped up. They said today in the hearing that they were at about 70 pages. They then have their illustrations and appendix on the banned items that the judge has called for, which are not included within those, but to be filed at the same time. Let's see, there will be an oral argument. So you have March 2nd, the state is due with their brief. The reply brief on our end is due 21 days later. That would be March 23rd. And then the judge looked at his calendar and has set April 12th, Wednesday, for oral arguments. There are going to be oral arguments in this case. And with this, the judge was very cognizant of everything that's going on. He was aware of the Naperville decision and said he had read the decision. He is aware of the cases that are taking place in California. He is wanting to build a full record. He wants to make sure that both sides get the opportunity to get whatever they think they need is to build upon the record, to get it into there, because the trial court is where this is. And this isn't even a full-blown trial. This is just a motion on a preliminary injunction. And so the state is going to have their expert declarations and all that stuff filed next week. Our side will then get 21 days to go through those and formulate a rebuttal to those, and we'll see how all that goes. The judge, being aware of the other cases, he did make a comment that if another case were to come down somewhere else, we weren't going to need to rebrief and argue the whole case. He was just, file a letter, an essentially judicial notice, staple a courtesy copy of the case to it, and file that with the court, and he'll just take it as a supplemental filing in lieu of everything else. A couple of things that were interesting. So the McHenry County State's Attorney is named in the SAF ISRA case. And in that, he is the defendant in this case. The same McHenry County State's Attorney who filed a suit against the Attorney General's office and trying to have this law struck down. And he said, his representative said today, that they were not going to be able to reconcile those two positions and would not be falling in with the defense of the Attorney General's office of this statute. It also appears that at least one other state's attorney is going to not fall in with the Attorney General's office, and they weren't sure if they would simply sign on to our side's briefs, if they would acquiesce to our side's briefs or file their own, but it indicated that they probably would not be filing a huge, long brief in support of the Attorney General. And one has to think that any state's attorney from that part of the state that sided with the Attorney General would look like, they are, it would just be a political suicide for them to come out in favor of this broad of a gun ban down there. So we've got a week to wait to see what the Attorney General does. I'm sure that is going to spurn a lot of talk and a lot of, we're going to tear it apart. They're going to have 80 pages. We'll see how much garbage they're going to throw in there. We've already seen some of the garbage they've thrown in other cases. They admitted that it probably what we were going to be facing as part of our argument for why we should have a reply brief is that we don't know what they're going to throw out there. And this is a case of almost first impressions post New York, and therefore it would be only fair for us to be able to rebut a bunch of the garbage they're going to throw out there. And with that, the judge thought that was fair to make sure that our side got what we needed in there. But they did admit that it probably wouldn't look too different from what California has thrown out there, which they're following these other cases just as we are. That's interesting. I think that Judge McGlynn was fair. One of his comments was that in the orals, they have scheduled 2 hours. So they have given an hour to each side. Obviously, the AG is going to be arguing everything. Then we will get probably divided time for various attorneys to come in. But the judge admonished all the attorneys that he doesn't want repetition. He doesn't want duplicative arguments. It's not going to be you get 15 minutes and then you come up and argue the same stuff for 15 minutes. No, he wants different and concise arguments. One of the things that he said was that, if this goes past 2 hours, I'll have my clerk wake me up when you make a relevant point and you're not being redundant. So the judge there is very, very aware. And in terms of judicial economy, he doesn't want people just simply regurgitating the same thing over and over and over. I like the way the judge handled the hearing today. He's all business with a little lighthearted streak in there. But he's also an old school judge from the standpoint that he wants some oral arguments. He wants to ask questions. He wants to delve in behind the briefs a little bit. And I think that's going to be telling. It's going to be a fascinating set of oral arguments, and I think that when all the documents are filed at the end of the day, I think everybody's going to be very interested and impressed to see how this goes with our side. So, with that, as always, thank you for listening and sticking around. We have broken 6,500 and heading towards the 7,000 mark on our subscribers. So please like, share, smash the subscription button, copy, paste the link, and pass it around to social media sites, your Facebook groups, blogs, chats, whatever you're on. We really appreciate all that. And we'll be having some more updates. So you can figure that probably next Thursday, depending on how early or how late the AG files their information, their reply, that we'll be getting another video out on these 4 cases in Southern Illinois, and go from there. So as always, thank you again. Frag out.